Okay, I think we can begin. Well, everyone, I'm going to have our executive director of the Barbra Schlifer Clinic do the welcome for today's session. So I'll hand it off to Deepa. Go right ahead.
Thank you so much, Landra, Callie, as we call you. Welcome everyone to the Criminalization of Survivors launch forum. Thank you so much for joining us today. We had some 99 people registered for the forum today, and I know that people are still trickling in, and they will probably throughout the forum. We would like to start our next 2 hours together, or 3 hours together, I should say, with land acknowledgement to acknowledge the privilege that we have of being on this land. Some of us are here by choice, and some of us are here because they were brought to this land. So acknowledging the contribution of everyone and the privilege that we all get to enjoy, to work on this land, to cry on this land, and to collaborate and support each other on this land. So there's a video that Clinic has put together, and hopefully all of you can watch it with us and get the grounding that we all need to do this work every day. Thank you so much. And I invite Callie back into the room to share the agenda and the remarks.
Thank you, Deepa. We're going to start with a survivor story next. This is a survivor who has gone through our Criminalization of Women program, which is the basis of this project, what we're jumping off from. Then we'll tell you a little bit more about the project. We'll have a panel discussion featuring Deepa, Janet, and Emilie, and we'll go into breakout rooms after the panel discussion. There'll be a break between the panel discussion and the breakout groups, just so you're aware, and then we'll do concluding remarks. So that is the agenda for today. And here is Suzanne's story.
Hi, Suzanne. Thank you for coming today. I just wanted to ask, before you seek the support from the clinic, how was life for you?
I was feeling alone, extremely lonely, suffering, violence, and due to the stigma, I didn't want to seek help. But my doctor, he encouraged me to come to Barbra Schlifer, And I was aware that this clinic was available for women that are going through violence.
Then how is the clinic supporting you right now?
I go housing, thanks to the housing worker. I got priority, and I'm on the waiting list at the moment. There's a person escorting me to court and to navigate the justice system. I feel that I'm not alone.
What advice you would give it to people who are in a similar situation?
There is help around. And Barbra Schlifer is one of the places that can help them stop, which is not, abuse is not acceptable. And to come to the clinic, they will be treated like a person, like a human. And by doing that, the dignity is coming back to our life.
Thank you. Hi, Susan.
So a little intro into this project, which is, like I said, it's a step. We've used the Criminalization of Women project as a stepping stone. So this project is called Criminalization and Survivorship. And what we're doing is we're scaling up promising practices from the clinic's Criminalization of Women program. Our program has run for many years, and in the last 3 years, we served over 500 clients. And we're going to use the practices of this program and try to expand it to other areas of the country, so that more people can be helped in addressing gender-based violence and criminalization. So this is a 30-month project that will run until March 2026. And it began in January 2024. Myself, Calandra Cochran, I am the community engagement lawyer. And there's also the national project coordinator, who is Rosa, who's on the call as well. The locations that we're seeking to reach out to and do forums at and build partnerships in is Edmonton, the general Greater Toronto area, Montreal, and Halifax. So that's a little primer into the project. We will get a little bit more into what the project's going to be doing after the panel. So yes, and also I forgot to mention that if you need interpretation, you can click on the globe icon and then click French, and you can get French interpretation. So before we get into the panel, I'm going to introduce each one of them to you. So Deepa Mattoo, who gave the welcome today, is our executive director. She's an award-winning lawyer and intersectional feminist whose work is rooted in equity and anti-oppressive and anti-racist practice. As our executive director, Deepa provides leadership to various departments and for the clinic's intervention and advocacy work, and has appeared before the Supreme Court of Canada, Parliament committees, and the UN civil society meetings on a wide range of social justice and human rights issues. We're also joined by Janet Mosher, who is an associate professor at Osgoode Hall Law School. There we go. And the co-founder of the Feminist Advocacy Clinical Program that runs here at our clinic. Her research focuses on law and gender-based violence, access to justice for marginalized populations, welfare policy, women's homelessness, and legal aid. And finally, we're also joined by Emilie Coyle, who is the executive director of the Canadian Association of Elizabeth Fry Societies, a national organization that works with and on behalf of criminalized women and gender diverse people. So thank you all for joining us today, the panelists. It's an honor to have you here today. As we begin, I think I want to set the stage with defining what criminalization is so that the audience is aware of what we're talking about when we talk about criminalization. So when we're talking about criminalization today, we're referring to when a gender-based violence survivor experiences punitive state action in response to them experiencing, defending, addressing, or seeking protection from GBV. It is important to note that criminalization includes not only experiences with the criminal legal system, like that of arrest, criminal conviction, and incarceration, but also systemic targeting and surveillance of persons from equity-seeking communities by the state's criminal and quasi-criminal systems and institutions. So to start us off with that definition, I'd like to ask the panelists, in what ways are survivors currently criminalized today? I think we'll start with Deepa on this question.
Thank you so much for the question. And again, thank you to everyone who's joining us. It's an honor to be speaking on this topic with Janet, Mosher, and Emilie, two people I really look up to when we talk about the criminalization of survivors. And in terms of how survivors could be criminalized, I think, unfortunately, at this time and state of our legal instruments and the way they work and our legal policies, the way they work, there are many reasons and many situations where we see survivors being criminalized. One of the most common one that we see is an outcome of the mandatory charging policies, where we see survivors who are experiencing long-term, sometimes short-term, but generally speaking, for the duration of their relationship, they're experiencing violence. And instead of getting help for the experience of the violence, they land up getting charged when they interact with the criminal justice system. And it can happen for many reasons, and I think we will dive deeper into that later in the conversation. But then that's not the only reason why we see women or survivors and gender diverse people criminalized. We also see folks in a situation of sex work and trafficking. We see they are arrested, charged with the related offenses, and rather than being recognized and treated as survivors and people who need support and human rights, we find them to be having on the wrong side of the law and having a criminal record, which actually takes their ability to rebuild their lives or find housing or secure employment, all of those things more difficult. Immigration status, substance use, homelessness, or and I would rather say people experiencing homelessness. I learned this morning that calling people experiencing homelessness is such a pathological way to talk about it, and just passing on that wisdom. And most definitely experiencing of the child welfare intervention and child protection interventions that we also see where there is mandatory reporting that happens against survivors. I will just touch on the themes broadly speaking, because I know that Janet and Emilie will probably go deeper into it. But just from the clinic's perspective, the immigration status is one piece that we find, survivors find that they are continuously fearful of reporting the abuse because they are continuously living under the pressure of this control mechanism that, if you say something, we will get you deported, or they're undocumented. And as we talk about the feminization of this whole immigration status issue and the deportation of the threats issue, there is also a very related issue of racialization of these particular communities. And I think our conversation today won't be complete unless and until we talk about that all of these issues that I just talked about impact racialized and indigenous communities way more disproportionately as compared to other communities. So I'll stop there because I know that I have other experts with me today who I learn from every day. So I'll maybe ask Janet and Emilie to go deeper. Emilie, I think, is the next person.
I am very deeply grateful that the Canadian Association of Elizabeth Fry Societies has been asked to speak with you on this panel. And the reason that we are grateful is because people who are in our prisons and jails who have experienced criminalization are often not included in the conversations that we have around gender-based violence. And so I think the very fact that you are doing this project on criminalization and survivorship is a great step forward in terms of our understanding of the realities of people's lives. And although the topic that we're going to be discussing is very dark and can feel really heavy, the fact that we are gathering today, we're having these conversations, actually gives me a lot of hope for how we will proceed in the future. And we'll talk about that a little bit later. So CAFES is an organization that works to address the persistent ways that criminalized women and gender diverse people are denied their humanity and also excluded from considerations of community. And often that's because we have this really strict binary between victimhood and perpetrators of violence. And in fact, we know in our lives and in many of the people's lives that we work with that these are not strict delineated lines, that there's a lot of blurriness. And so the ways that people become criminalized, in addition to what Deepa has already suggested, is also present. All of those things that you said are present in the lives of the people we work with. But also, once you have a criminal record, or once you've been to prison or jail and you leave prison or you're on bail, you'll have conditions of probation or parole. And those conditions can be quite strict. And if you are in any way if there's any way that you are not abiding by those strict conditions, then you can become recriminalized, which is something that we don't talk about. And there are very particular gendered conditions that apply to most of the women and gender diverse people that we work with that we don't really see in the same ways with men who are leaving prison. And one of those is conditioned um, to report all of your relationships, any relationships. And there is a really gendered aspect to how we talk to women, how we support women, and how we infantilize women when they come out of prison, that we need to control their relationships because they obviously can't control their relationships themselves and put them in further harm. So we're going to do that for them. And then also conditions to not use particular substances, which of course is really difficult for people who are struggling with substances. And so that I'll just wanted to add those as nuances to the conversation, and then we'll get into some of the details later. Over to you, Janet.
Thanks very much, Emilie. And it is a real pleasure to be part of this panel. And I, as always, will learn a lot over the course of the afternoon. I actually wanted to start with a broad observation that maybe takes us back to the very helpful and comprehensive definition of criminalization that Callie provided earlier. And that's just to say a little bit about the context in which many women and gender diverse people struggle to survive. So I think it's important that we're putting criminalization and survivorship together. So what is that context? This will be really familiar, no doubt, to all of you on the call, that over the last couple of decades, we've had this retraction of the social safety net. It was never, of course, perfect. It was always porous, but the gaps have widened, supports have thinned. And at the same time that that retraction has happened, that is retraction in social supports, some have described a rolling out of carceral approaches or law and order approaches. And that's both in terms of expansions in the formal criminal law realm, but also those same kind of logics you see in social assistance and immigration and education. So things like zero tolerance policies and proliferation of surveillance and the sharing of information across different regimes. And that combination of the retraction of social support and the expansion of Arthrologics means that it's massively increased exposure to criminalization for women and gender diverse people. There's lots and lots of examples we could give, and you've heard a few already. And I thought I might say a little bit more about immigration law and then maybe a little bit about social assistance law. So Deepa has already touched on immigration law. What you'd see more broadly under immigration law is an expansion of offenses that have very significant penalties attached. Many of these could be prosecuted under the immigration legislation, IRPA, or they could be prosecuted criminally. And that kind of proliferation of offenses under the immigration legislation, things that were often treated in many instances more as an administrative offenses before, become to look more like criminal code offenses. You've got a really significant uptake in enforcement, and you have a lot of information sharing between immigration and criminal enforcement, which leads many to describe this confluence of immigration and the criminal law as crimigation. So examples of the offenses are smuggling, trafficking, document fraud, and marriage fraud. And I took a few minutes this morning just to go onto the website for Immigration, Refugees, and Citizenship Canada to look at the warnings around marriage fraud. So this is from the website, and this is the warning. It's a crime to marry a Canadian citizen or permanent resident simply to gain entry to Canada. We'll refuse your visa, and we may ban you from travel to Canada for 5 years. This will be added to your immigration record and may affect future applications. And it goes on to say, our officers are very well trained and they know how to spot marriage fraud, including document checks, visits to people's homes, and interviews with sponsors and applicants. So you get a sense of the sweep of the surveillance. You get a sense about these warnings. And of course, also under the legislation, the offense for misrepresentation is a fine up to $100,000 and 5 years of imprisonment. So think for a moment about the power that this gives to a perpetrator who sponsored their spouse to allege a fraudulent marriage, threatened to have her removed from Canada, charged under IRPA, subject to a fine, potentially imprisoned. And that kind of significant threat, back to Deepa's point, keeps women locked in abusive relationships, but it also exposes them to potential criminalization. You can see as well that as the criminalization under IRPA is enlarged, it gives more power to her perpetrator to control her. So then briefly, in the context of social assistance, there were also offenses in Ontario Works Act and the Ontario Disability Support Program Act. There aren't a lot of prosecutions under the Act itself. There are lots of threats of prosecutions. There are prosecutions for welfare fraud, and there's lots of threats for fraud. And if you think about it, survivors are trying to survive on benefits that are horrendously inadequate. And again, it is almost impossible to survive without in some way violating one of the rules that might expose you to the offense provision under Ontario Works. The other thing I want to point out here is the ways in which language is used to create populations of people who are suspect and who are potential criminals. And this is part and parcel of the logic of trying to govern through crime. And we can think about the construction of the menace of welfare fraud and the language of frauds and cheats and liars and of theft, of zero tolerance. There's some really, really good work that's been done recently by Abdel Abelaji around the ways in which this particularly impacts Black women. I guess what I'd say here, and just to sum this up, is you can see in the context of receipt of social assistance, the potential exposure to actual criminal prosecution under allegations of fraud. And I'll talk later about how perpetrators use that as well as a tactic of control. Potential exposure to the provincial offenses under the relevant statutes, but also being exposed to a regime where you are constantly subject to intense surveillance and regarded with suspicion, where, again, I think women often describe feeling like they're being treated like garbage, they're being dehumanized, they're treated as though they're already criminals. So it's a really, really demeaning environment to live under. Maybe I'll just conclude by saying there's a couple of other discrete ways, I think, in which criminalization operates that maybe we don't pay a lot of attention to. And I'll just touch on these briefly, and maybe there'll be questions about them later. In the family law context, I'm surprised at how often there are contempt orders made where women end up incarcerated as a result of their contempt. And that contempt often arises because they're trying to protect their children. And in some of those instances, the perpetrator of the violence who's faced criminal prosecution and conviction does less time than the woman who's found to be in contempt of the court's order in the family law context. And another area is child abduction, both domestic and international, where again, women are engaging in self-help to try to preserve themselves and their children, and they face criminal charges, sometimes conviction. There is under the criminal code a complete defense if you've acted to protect yourself or your child from imminent harm. And I've just been reading through those criminal law cases. I'm shocked at how narrowly it's been interpreted. And also what's assumed to be a backdrop of adequate state protection. This idea that there's no reason a woman would ever have to engage in self-help because the state, this very benevolent, caring, supportive state is always there to support her and her children, which of course we know that that's absolutely not the case. So I will end there.
Can I just add one thing, Kelly, before we move on to the next question, if that's okay?
Of course.
Because I think, Janet, you brought up some really good points that I wanted to just explore a little bit more in the context of the work that we do. And I'm so grateful that you brought up Dr. Adil Abdullahi. She was one of our presenters at an AGM, and she really laid out in one of her recent books how the welfare system plays into criminalization, particularly for Black women. And it's so important. And so that led me to think a little bit more about what I could give to this conversation about the people that we work with. And people in prisons, according to the Office of the Correctional Investigator, who is the ombudsperson for the federal prisons, 80% of the women who are incarcerated in those prisons have experienced physical violence in their lifetimes, and 70% have experienced sexual violence in their lifetimes. And in addition to that, and it's something that's really important for us to bring up, is that the people who are in the prisons designated for women in this country, federally and also provincially, are by and large the poorest people, the people who are the most underserved by our systems and overly punished by our systems, because criminalization has an unequal impact, right? As you said, Janet and Deepa, and it can have a destructive impact on Indigenous peoples who are 50% of the population in the federal prisons designated for women. That's half. And I say that, and sometimes we trip over that really quickly, but that's a huge number. Half of the people in the federal prisons designated for women are Indigenous, and our population of Indigenous people in this country is only 4 to 5%. And if you go into some of the provincial jails and some of the prairie provinces, it's up to 90 to 99%, depending on the day. So that's really atrocious. Black people, trans people, sex workers, and others, and the intersection of those identities can make it very difficult for people to navigate systems. And then they are already surveilled. And so they're struggling under this weight of poverty, as you said, because we don't have the necessary social programming to support everybody. But we also have to talk about racism. We have to talk about ongoing colonialism. you know, anti-Black racism is also something that is really ever present in the prisons designated for men. And we have very young people who are being criminalized there as well. So I just wanted to add that to the conversation before we move on. So thank you.
I don't have to stick his floss.
Thank you. Thank you, everyone. I think we have some time to address how our current laws and policies affect the criminalization of survivors in a little bit more in depth. If you have any more comments on that, I'll just open the floor.
Just to add to what has already been said in terms of, sorry, in terms of how the legal instruments become are weaponized against the survivors themselves. I think one of the weaponizing that happens most commonly also is the retaliation from the abusers. And what we see is that abusers manipulate legal system to their advantage. And what they do is that they would falsely accuse survivors of crimes like harassment, or they will file false reports against them. And that, unfortunately, that whole process that the legal instruments allow that to happen is one of the challenges within the legal system, where we see that they are being the survivors are being criminalized, and then the failing of the law to protect the vulnerable. So Janet talked about it in terms of, that survivors being charged for child neglect or endangerment, and how many times we hear survivors being told that you have to leave the house and you have to leave the situation of violence, and if you're not able to leave, then we will be reporting. So that is something that happens not necessarily from the justice system player, that happens from the service system players, because service system players are designed around that legal framing, that if you don't take this action of leaving, we are going to be, because of the legal framework, we will have to report you. And then the criminalization process would start. And it starts very fast at times. So I think, if we take each theme and think about how the legal system gets weaponized against survivors, it will be very interesting to see how they are all interconnected issues. And I'm really liking the conversation about the fact that we are really looking at the various intersections, and we are not leaving the marginalization of poverty behind, because that whole challenge that everyone right now is talking about, inflation, everyone is talking about homelessness, and all of those play a huge factor in survivors being criminalized in the system, because it is that lack of housing, it is that lack of resources that puts survivors in a situation where they have to make difficult choices. And while making those difficult choices, what they're facing is not protection, but criminalization. So I'm just taking those threads and tying them together. One of the pieces around the immigration status, which also I want to say, is that it's not necessarily feeling to live under the threat that I'll get deported, right? Like that's one aspect of your experience. The fact that you're being looked as a possible criminal is that experience that I think we don't pay enough attention to that, unfortunately, even in service delivery, because when you're living your life as if you're walking on the eggshells, every time you're stopped, every time you're asked a question, and you basically live your life in a way that, I shouldn't tell anyone about my experience, I shouldn't talk to anyone, God knows who will report me. And it's not only your abuser, it could be your neighbor, it could be your landlord, it could be your employer. So the intersection of violence for the immigration status and the criminalization doesn't happen just from the intimate partner violence, it happens from various different layers. And I really wanted to also speak to that. Thank you, Kelly, for the follow-up.
Janet or Emily want to comment some more, or shall we move on?
I wanted to recommend to everyone a book. And it's a book by a lawyer from the United States called Lee Goodmark. And she writes about imperfect victims, criminalized survivors, and the promise of abolition feminism. And in reading her book, you get a lot of different stories and examples of how survivors are criminalized in the context of her work. And I think that's really important because we understand how systems work when we have stories to unpack them through. And so I look, for example, many of you are familiar with the mass casualty, like the man who killed many people in Nova Scotia in 2020 and or is it 2021, and the mass casualty commission that happened subsequently. But what a lot of people weren't aware of was that his partner, who he had severely harmed for years and years, was criminalized in the aftermath of his actions. And she was charged with, I think, providing weapons or something to him. And there was very little analysis or understanding of the years and years of abuse that she had endured, including, discussions about how he was going to kill her family. And I say that because it's a really stark example. The night that he ended up, the night and the day leading into his horrific actions, he had actually tried to kill her and was probably going to be successful if she had not run away and hidden in the woods until 6:30 in the morning. And then when she came forward and made her statement to the police about what had happened to her, she was subsequently criminalized and charged. And so it's a very clear example in our country, a very public example of how people can be caught up in the criminal justice system when they think that, and for many years, she didn't think she could go to the police because she thought that he would be above the law. And, again, her suspicions were reinforced when she became criminalized. So that's one example. And I can speak of some more as we go through them, but I wanted to just say that at the outset.
Thank you, Emily. I think we'll move on to the next question. For the next question, one of the key points of our project is not just criminalization, but it's also involving coercive control. And coercive control is defined as it is a form of gender-based violence, and it refers to patterns of controlling behavior, including threats and attempts to humiliate and isolate a partner. And it's often a strong predictor of physical violence as well. So I'd like to know what you all think of how does coercive control play a role in the criminalization of survivors?
We start with Emily.
Okay. I think I go first. Yeah. And I wanted to just say that there's a comment in the chat that these are not stories but lived experiences. And so I wanted to thank you and say that I agree, these are lived experiences, and I do not say that they are stories in order to minimize the lived experience of the people who have experienced them. And so thank you for pointing that out, Kelly. So coercive control is a really interesting new way that the government is currently trying to criminalize aspects of intimate partner violence. And the Mass Casualty Commission actually also spoke about coercive control as an element of intimate partner violence, and spoke about intimate partner violence in the context of an epidemic in our country, and that we should be addressing intimate partner violence using epidemic levels of resourcing to organizations that deal with intimate partner violence. And it's a really pervasive form of intimate partner violence that most of the people that we work with have experienced. And it, particularly a very, also another public example of this is the example of a woman named Helen Naslund, who has been in the media a lot, and there's a podcast that she participated in. So I'm not speaking out of turn by telling you anything that is private. All of this you can find online. But Helen Naslund experienced extreme violence at the hands of her partner, and so did her children, for 30 years. And she did end up going to prison initially for 18 years, and then on appeal that was reduced. Her sentence was reduced because she ended up taking matters into her own hands. And if you listen to the podcast or if you read any of the media about her story, you will understand that it was many, many years of her trying to escape without any indication that her attempts to escape would be successful. And in fact, they weren't. A couple of times they were really unsuccessful and resulted in more violence toward her and her children and her pets. We don't often talk about animals, but pets can be used as well as a form of coercive control over a person. And so because many people who have experienced examples of the system not protecting them, particularly the legal system. We work a lot with people from Indigenous communities and Black communities and poor communities, where they understand that if they were to reach out to the systems that are ostensibly there to help them, that they won't get the help that they need. And in fact, it would put them under an even larger microscope and potentially lose the custody of their children. And so they definitely will not report it. The other issue with coercive control is that it's really hard to prove. And if you are going to put someone on the stand who is a survivor of coercive control, you may be putting them in a place where they have to relive years and years of trauma and being questioned on that. So we have some practices in our criminal system that do not lend themselves to people coming forward for fear of having to relive these particularly traumatic parts of their lives. And I think about the statistic that I gave you earlier about the people who are most incarcerated in this country, but we also have to mention that Indigenous women in Canada are more likely than other women in Canada to have experienced intimate partner violence in their lifetime. And so we have this dual issue of mass incarceration of Indigenous women, and then we also have this issue of underprotecting Indigenous women and gender diverse people. We aren't preventing harm from coming to them, and we also regularly criminalize them. And so an answer of criminalizing coercive control is going to further damage the lives of the people that we work with. And we understand where that impulse comes from, right? Like we know in the 60s and the 70s and the early 80s, when we were looking at how we could, as a society, address intimate partner violence, particularly because it does affect women and gender diverse people more than it does the other gender, then we, because of that, it was a real push by the feminist movement to look at how we could respond to intimate partner violence, for which coercive control is a really big part of that. And we thought the criminal law would be a good response to that at that time. But intimate partner violence has not subsided, despite the many efforts to criminalize over the last 30, 40 years. And so we have to then say to ourselves, okay, we've but it's making it actually worse for those people who are already criminalized, already overly surveilled. So if that's the case, why do we continue to double down on a criminal legal system that is obviously continuing to harm people instead of protect them? So I'll pass it over to, I think it's over to you, Janet.
Yes, thank you. And I was going to start by really trying to hone in on just the ways which we might anticipate that coercive control is used in the criminalization of survivors. And then I think the other issue that Emilie is speaking to is this question about the current efforts by the federal government to create a new offense of coercive control. So I could address that now, or I could address it a bit later. So I know Callie has very helpfully, again, shared a definition of coercive control. And I thought I might just start by saying that there are a lot of different definitions of coercive control. And there's some maybe broad agreement that what we're focused on is a shift away from a discrete incident, which has been the law's focus, to looking at a pattern of behaviors over time and just what are the behaviors that are relevant. Well, clearly threats are relevant. Isolation is, I think, often a really significant part of coercive control. But depending on the women or gender diverse people that we have in mind, the kinds of tactics or behaviors that might be coercive or controlling are really dependent on their particular identities. So something that may not be, if directed towards me, may not feel intimidating or coercive or controlling for a woman in a very different space and location with different identity markers than I have, could feel very threatened and intimidated. And I think there's, at least in what I read, in the pickup of, especially around criminalizing coercive control, not a whole lot of attention to that level of nuance. I think often it's described using a metaphor of a web or a cage, that these various tactics are used to essentially undermine a woman's autonomy and her liberty. And again, we could think about the different levels of autonomy or liberty that are enjoyed by women, depending, again, on various identity markers. So factors like race, sexual orientation, et cetera, are all relevant to how we think about those issues as well. So if I try to connect up this concept of coercive control to criminalization, I think can operate in a variety of different ways. One, which is very clear and explicit, are threats to women or others to engage. If you don't engage in this criminal activity, X will happen. And X could be a threat of harm. It could be to take your children. It could be a whole variety of different things. This work goes back a while ago. Beth Ritchie did interviews with Black women in Rikers prison in New York called Compelled to Crime. And that's part of what she finds in her interviews with the women imprisoned there. The story is more complicated than that, but that's part of the story, or part of the account, part of those lived experiences, I should say. Something that Deepa alluded to earlier, and that is threats to report to various state institutions that control a woman's access to benefits or entitlements, alleging that she's engaged in fraud, misrepresentation, and those kinds of threats are made and actual reports are made just to a huge variety of different actors. Social assistance, social housing, subsidized daycare providers, Canada Revenue, especially in relation to the Canada Child Benefit, border control agents around, for example, marriage fraud or other forms of alleged misrepresentation. And to give a specific example in the social assistance context, he might, for example, call social assistants to say he's living with her as her spouse. So that he will prompt an investigation with an aim of having her cut off benefits and potentially charged with an offense under Ontario Works legislation or criminally with fraud. Research that I did some time ago with women in receipt of social assistance, they described the threat of welfare fraud as a weapon that keeps them trapped in very abusive relationships. So again, abusers make these kinds of threats, I think, routinely, and they are enormously powerful. Threats to report to child welfare authorities, again, to prompt an investigation, sometimes specifically designed to try to hurt her in a way that he knows is profound, and that is to try to have her separated from her children. In some of the family law cases, it's just remarkable to read how many times he's reported her to child welfare agencies. And again, heavy forms of surveillance, significant risks at play for the mothers. He threatens to report to the police, or he does report to the police, that she is the perpetrator of violence and he is the victim. And this, I know the clinic has lots of experience and examples of this happening, and especially where he's much more fluent in English than she is. And he really ends up controlling the account that is given to the police and on which charging decisions are made. And these kinds of allegations and actions escalate when she says she's going to leave him or she leaves him, and he's trying to reassert control. So he feels he's losing his control and he tries to reassert it and trying to increase her dependency on him, or her limiting her ability to be able to survive without him. And I guess maybe the last thing that I'll mention here, and then we can come later to talk about the proposed legislation, is just a form of violence that in some of the literature is described as resistive violence. And that's meant to capture an idea that, especially if you've been entrapped for a lengthy period of time in a very abusive relationship, that you may take particular kinds of actions to try to break free of that cage, to escape. And those actions may involve forms of violence. They may be forms of personal violence. They may involve destruction of property. They could take a variety of different forms. But I think very often what happens is those acts are not understood in the context of the overall relationship, and the understanding of the pattern of coercive control that's existed for a very long time. And then maybe a bit later in the conversation, we can come back to the question, is creating a new offense of coercive control a good solution? And a quick answer is no, I don't think so, but we'll come back to that.
Thank you, Emilie and Janet. So just bringing it back to a little bit of the clinic's experience. So Callie told all of us that, the clinic has served around 500 clients in this area. We speak to at least 5 to 6 clients, new clients every week around this experience of criminalization. And I can say almost in all the cases that we do some kind of intervention we see that survivors are experiencing a pattern of violence from their abusers, which definitely includes domination and manipulation. But I think a couple of things which maybe are to be observed and noted, that almost all of these clients are experiencing various other forms of marginalization that we have been discussing earlier today. And what they experience is manipulation of the legal system, which includes false accusation and the gaslighting, which is literally manipulating them to believe probably that what they have been doing was wrong all this time, and therefore they are responsible for the situation the clients are in. So making survivors really be manipulated in believing that, and unfortunately, this manipulation not only happens by the abusers, of course, they manipulate and they falsely accuse them, but it's also the way system engages with the survivors. They are made to believe that they are probably the primary aggressor. They are the ones who probably should not have retaliated or defended themselves, and hence they are in trouble. And that, I think, is state-induced or legal system-induced coercive control that we don't necessarily talk about as much. But coming back to the intimate partner violence situation or gender-based violence situation and coercive control, forced criminal activity, I think both Janet and Emilie talked about it. That's something that we commonly see in the situations that we deal with here at the clinic and intervene in. We see a lot of abusers coercively influencing survivors to commit illegal activities or get involved with drug trafficking, theft, or basically committing anything which they don't want to under the threat of violence or repercussions. And then also making them legally responsible, which is actually an operation of the abuser. Callie talked about coercive control often involving isolation from the family, friends, and other support networks. I also want to kind of reiterate what Callie was alluding to, which is that coercive control is an indicator of high risk. And it is an indicator of high risk, not only for physical violence, but also a higher level of emotional manipulation. Now, the question comes that what is the impact? Legally, we are knowing that the impact is that you will find yourself criminalized in the system. But other impact, which we don't look at necessarily in the legal settings, but at the clinic, because we provide services from both legal and counseling side of things, what we see is the prolonged level of stress, trauma. We see a lot of anxiety related to this behavior, and also the healing delay coming out of these experiences. Even if your charges are dropped, even if your record is taken care of, we find survivors really losing faith and trust in relationships, and their healing getting really delayed. In terms of the question around should it be criminalized, my answer is also no, and we can talk about why. I mean, just to give you the sense of like what the clinic's position has been during a lot of these House of Commons debate and House of Commons, when we are invited to be a witness and studies, what we have been saying again and again is that if mandatory charging has not worked and has not been helpful, how do bringing in another section on your books, which again will not be properly understood, not properly be resourced, a legal system which is already overburdened laced with so much bias, how do we really expect it to work? But I can go more into that when we get to that question. I think we have a question in that later. But yes, the short answer is no, definitely. And one more thing that I think maybe is really important to understand is that when I'm saying almost all, I'm literally saying every case that we have dealt with in the Criminalization of Women project, it's almost 100% that you will find one or the other form of coercive behavior that the survivors have experienced. But 90% of those clients have also experienced many other forms of marginalization, which could be racialization, which could be living in poverty, which could be living in a precarious immigration status, and so on and so forth. Thank you.
Thank you, everyone. Another part of this project, as well as coercive control, is litigation abuse. And litigation abuse is when the abuser uses legal tactics to assert power and control, such as maybe filing repeated applications in different forums and making lots of motions, trying to delay the process. In what ways does litigation abuse play a role in the criminalization of survivors. Deepa, I believe we started with you again.
I'm saying that we didn't think it through. I ended and I'm starting now. I feel like I'm taking too much oxygen in the room, so I apologize for that. So in terms of litigation abuse, which is a tactic often employed by abusers to maintain control over their survivors, or through the legal system, is in terms of the experience of criminalization, it significantly is a contributor, because what we see here at the clinic is and for 1 second I'll change the gears and I'll bring you to the civil and family law environments, and then maybe I can go back to the frivolous legal actions around the criminal actions, because we have been talking about that quite a bit. In terms of the civil and cases involvement and family law involvement, I think there are two things that are worth noting and thinking about. One is that we see abusers claiming parental alienation in the cases of disputed parental arrangements, and we see that they try to portray survivors as an unfit parent, and that's where the conversation starts. It is about the dispute and creating litigation and motions after motions, and that's one of the tragedy of the family law disputes. But the leading that leading of that takes to legal consequences of a lot of litigation abuse, but also sometimes criminal charges that then will interfere in the parenting arrangement for the mothers and gender diverse people even more intensely. And so that's one pattern that we should probably take a note of. Another pattern that we should take a note of is that in case of the survivors of sexual harassment, we see that there is a lot of non-disclosure agreements that are signed by the survivors. And again, they are made to feel that if you disclose this settlement, you will have a legal action started against you. So somehow what you would do would be an illegal behavior, hence a criminalizing behavior. And we also see that in this era of, post Me Too era, we see a lot of defamation cases filed against survivors, which also at times includes activists and spokesperson and people who, want to talk about the issue of gender-based violence, they being silenced and controlled through the litigation abuse or litigation per se. So those are some of the legal actions that will be, I would consider them outside the typical quintessential criminalization behaviors. But then the criminalization behaviors within the criminal justice system are violation of the court orders or violation of any of the conditions that are imposed. I think Janet spoke about it earlier briefly. We also see there is a lot of manipulation of the legal outcomes. That is done by making false claims throughout the process of legal, litigious experience, especially where there is someone who's over litigious and wants to raise every little issue and want to make charges on every new thing that they can find. And unfortunately, something that I want to say about litigation abuse is it's also to be raised with the legal professionals who assist over litigious people who try to use litigation as a modus of coercive control and controlling the survivors. We also see that litigation abuse is deployed because it creates an excessive financial burden on the survivors. And knowing that survivors a lot of time don't have the access to the same kind of resources as their partners have in intimate partner relationship, we see that there is a control of the legal outcomes that they can achieve through any logical legal steps that is controlled by the abusers. And the bottom line is that they want to create so much stress and emotional toll with this relentless litigation that can impair survivors' judgment. It can impair their expectation of the system, and we see a lot of harm that is caused. And this is unfortunately post-exit, because all we know that leading up to exit, there is a lot of challenges that survivors face. And now we're talking about a post-exit behavior, which actually keeps them keeps them involved and tangled into a lot of complexities, and that actually leads to a lot of vulnerabilities that not only changes their perception of what the system is, but it actually is the unjust system that they find themselves in a cycle of abuse and control, which continues after the exit. Thank you. I can say a lot on this, but I'll try to restrain.
And Deepa's given a really comprehensive overview, I think, of the various ways in which litigation abuse manifests and how it connects to criminalization. So I'll make a few points. Some I think maybe repeat or hopefully build on what Deepa's already said. So I could reference back to my earlier comments about the ways in which perpetrators rely on multiple different legal domains to make false and malicious kinds of reports. That to me is a form of litigation abuse, very clearly. I think another observation that Deepa made about the ways in which systems are complicit in those various forms of litigation abuse. It's extremely rare that a judge or an adjudicator in another context calls out that behavior as abusive. Like, it almost never gets named. And I think in that way, systems are very complicit in enabling this kind of systems abuse. I think another manifestation of litigation abuse, and you see this certainly in the family law context, the criminal law context, is the pervasive reliance by the perpetrator, and in many instances, again, to Deepa's point, perpetrators' counsel, their lawyer, on myths and stereotypes, where they know there is no foundation for the kind of assertion that they're making. So to give an example, in both family law and criminal law, it's extremely common for the perpetrator to say she has fabricated all of this to get the upper hand in custody litigation. It's just absolutely pervasive. There rarely is any foundation upon which that assertion is made, but it gets repeated over and over again. To me, that is a form of systems abuse, and one that lawyers often perpetuate, and it has really destructive consequences. I should say that accompanied with this, and more directly connected to criminalization itself, is, in addition to saying she's fabricated this, he usually also says, and I'm the actual victim and she is the perpetrator. So points the lens onto her behavior as she is the perpetrator. I would say another form of litigation abuse, and again, this is common in the family law realm, is for the perpetrator to assert that the mother suffers from some form of mental health disorder. And sometimes because, and again, I'm quoting a family law judge here to say, and she's describing a father in one case as cleverly manipulative. In that way of being cleverly manipulative, he sometimes frames this as he's really concerned for her well-being. But, he may then call the police for a wellness check, he calls CAS, and he invokes these systems of surveillance upon her. So for me, that's another form of litigation abuse that connects up with criminalization. And then maybe lastly, and here again to something Deepa has already said, is again, in the family law context, fathers' claims of parental alienation are pervasive in response to the mother's allegation of intimate partner violence. So she alleges intimate partner violence, and he says, no, parental alienation, the reason she's trying to, or she is limiting my contact, it's not to protect the children, it's to alienate the children from me. So it turns, like, the mother's protective stance on its head, that she's alienating the children. Many of you will know there were amendments to the Divorce Act and the Children's Law Reform Act in 2021 with a new definition of family violence that includes coercive and controlling behavior. And together with a couple of colleagues, we've just been recently going through the decisions to see how judges are interpreting and understanding coercive and controlling behavior. By and large, they're not getting it, but that's another long story. But really disturbingly, in a couple of decisions where the mother raises domestic violence and the father says, oh, no, what's going on here is she's alienating me from the children, is the judge has then taken that and said, she's engaging in control. That's a form of coercive and controlling behavior. Therefore, she's engaged in family violence. And then we might think about how that's been spun in the family law cases. And again, foreshadowing our discussion that's to come, what that might mean for the creation of an offense of coercive control under the criminal code. And again, the ways in which it's going to be potentially used against women. So yeah, I think there's just a whole variety of ways in which litigation abuse is perpetuated sometimes in ways that really do further criminalization, and again, which are just so rarely ever called out by system actors.
I feel like this conversation has been already so fulsome. I'm not sure if I can add very much to it other than to draw people's attention to the National Association of Women in the Law's work on exposing and debunking the social science behind parental alienation, and asking that parental alienation not be a consideration in family law cases at all, and rather pointing to the actual acts that are happening within the family. Not to say that there aren't oppressive acts that are happening, but that in calling it parental alienation, you give it this large name, and you erase all of the things that are potentially happening, and it ends up harming overall. They've looked at the cases in Quebec, for example, where a father has accused a mother of parental alienation, and that is usually believed. And when a mother accuses a father of parental alienation, she is usually not believed, as you said. And then there's also the discussion, as you said, around mental illness, and a lot of people are a long time ago, I used to do family law, and there was a lot of throwing around of the term narcissism and narcissistic behavior in families, particularly towards the moms in the family. Oh, great. Thank you, Callie. I also think there's some wonderful experts who are here and who are putting great things in the chat. So I'm really looking forward to talking to them later today.
Thank you, Emilie. So here comes to the paramount point of the government criminalizing coercive control, and would like your thoughts on that. Maybe we'll start with, Emilie again, and we'll get to that point. Thank you.
Yeah, I mean, I think we've already sort of talked about what we all feel about criminalization of coercive control. I think, so somebody put in the chat, and this was going to be one of my points as well. In the Mass Casualty Commission, there's a number of recommendations. And one of them, in addition to the resourcing of, epidemic level resourcing for organizations, there was also prioritizing the safety of women by shifting funding away from carceral responses toward primary prevention. And so the danger in criminalizing coercive control is that we then just leave it there. We say, okay, well, we've done something about it. It's now in our criminal code. And obviously the system, which works perfectly, as Janet said earlier, is going to do very well with this new law, and is going to address coercive control well now that we've criminalized it. But, the Mass Casualty Commission also took the time to say, we need a panel of experts who understand coercive control, who can look at what we need to do in this country before we take the action to criminalize coercive control. That didn't happen. There is no creation of an advisory council yet. And so that's something that we certainly would be pushing before we would look to the criminalizing of coercive control. And I think also the point that Stacey made was that there is a potential discussion around the self-defense of coercive control being part of the criminal landscape, which is an interesting thing for us to explore as well. Because, we're all trying to figure out how to utilize the tools that we have. Right. And the criminal law is one of those tools that we have at our fingertips. But unfortunately, we've seen over the years that the criminal law has not been successful in eradicating the things that we think it would eradicate. However, we also see the criminal law as an indication of our values, right? Like we are criminalizing things that we don't agree are good. And so some people would point to that to say, well, putting coercive control in the criminal code indicates to people that we think coercive control is a really big problem and that we want to address it. And I would say to that argument that there are other ways that we can do that don't harm people in the process. I think that we can certainly look to prevention of violence, how we can engage with training, with education, public campaigns so that people can understand what coercive control is. It's interesting because Scotland has criminalized coercive control now. And in speaking with one of the architects of that criminal law in Scotland, what she has said was, so far, and it's very new, they haven't really seen any positive uptake in that law in the ways that they had hoped. And there were a few reasons why that she indicated. But one thing that she really did like about the criminalizing of coercive control was that there was suddenly a large public debate, and that people who were at policing and in other institutions understood what coercive control now meant. And so again, I say that that's something that we can achieve without having to put it as part of our criminal code, and without having to then see the negative effects that it will have on the people that we work with, some of whom are already made vulnerable by all of the systems, including intimate partner violence laws, as we've discussed already, that are already on the books. So the advantages, I would say, are not outweighed by the disadvantages. And I would argue that we should be looking at alternate ways to deal with this really pervasive issue. So yeah, and I looked at some of the comments here about legal aid and legal aid certificates. And certainly, it can be a really big issue when there is discrepancy in families in terms of the financial abilities of the two partners, and often the financial controlling of the family means that the person who has the control of the finances can pay for a lawyer, and the person who is trying to escape the coercive control and the violence has to get a legal aid lawyer. And legal aid lawyers, having been one, you don't get very many hours, and you just don't get the time that is necessary to do the complex work. These are really complex cases, right? Like you can't do it quickly. You have to get to know the people. You have to have the trust of the person that you're working with to get to the heart of the issue. And if you only have a certain amount of hours at limited time, with limited funding attached to it, you can't get things like an expert's report that you might need to prove something that you want to, and you certainly just don't have the time to delve into the really complex issues to bring them forward to the court in a way that the court would understand. And so I think that that is something that we need to really look at as well in as we move forward with this. So I'm not sure who's next.
I think it's me on this one. And I don't know, how are we doing for time, Kelly?
We're going a little bit over, but perhaps maybe what we could turn to for you and Deepa is, what are your hopes for the future?
Gotcha. Okay, maybe just a quick word too about criminalizing coercive control. I'll be very quick. I just want to echo many of Emilie's comments. I won't repeat all of them, but in particular, the recommendations from the Mass Casualty Commission around ways forward, and that those ways forward should not emphasize carceral responses. And part of that comes from a recognition of the ways in which we can learn from our past efforts at criminalization and what has gone so terribly wrong. Because I think there's very little evidence that it's functioned either as a specific deterrent or as a general deterrent. And it's clear that there have been many harms as a result. So this whole conversation about the ways in which survivors end up being criminalized. And the other piece of the harm has been what happens when women or gender diverse people make disclosures to police and they're not believed, or when they're met with a whole range of hugely problematic embedded stereotypes and assumptions. What happens when if a prosecution goes forward, very, very few survivors report that felt like anything like justice. So there's a whole slew of harms, and those harms have not been equitably distributed, right? Those have impacted more profoundly on marginalized women, so Indigenous women, Black women, low-income women, women with disabilities, etc. And so the report of the Mass Casualty Commission also speaks very directly to that. And there's a wonderful background report that was prepared by an organization in Nova Scotia, Avalon, together with Leave. And many of you will know there were many low-income, marginalized, racialized women who, in a whole variety of ways, were exploited by the perpetrator, and where they had no safe place to go to make those disclosures, to get support, to get advice. And so it's just pretty clear that our existing criminal law system has failed. So I think Emilie said this earlier about why would we double down on that system at this juncture? It doesn't mean that the criminal law system has no role to play. Of course it does. But there's a huge amount of work that needs to be done around improving what exists already, around knowledge and understanding related to gender-based violence, around access to good quality representation. Just a huge amount of work that needs to be done, I think, before we would want to in any way think about expanding the criminal law system. So hopes for the future. Yeah, it's sometimes hard to be hopeful, I find. Obviously, from this conversation, there's massive kinds of reforms that are needed. And I won't go through all of those. I think they're pretty clear from what we've said. But where does hope lie? So I think hope lies in projects like this that the Schlifer Clinic is undertaking, and the sharing of knowledge among a number of people who are committed to doing this work. And I've not been able to keep up with all the comments in the chat, but from what I've been able to read in the chat, there's just a huge amount of knowledge and expertise in this Zoom room, and thinking about all the ways in which we can share that knowledge and expertise to build better systems of support. There's a whole lot of work to be done in upskilling, I'll say, lawyers and judges, frontline service providers, and a whole a range of different areas of practice. And some of that work has started. There's much more attention to trauma and what trauma-informed practices might mean. There's a huge amount of work to be done there, but you can see movement. There are things happening there. There is some growing awareness as a result of the Renfrew inquest, the Mass Casualty Commission report. I remember hearing Mary Ebert speak some time ago, and what she described, it's not very promising, but over her years of doing this feminist advocacy work, seeing moments where there's kind of increased awareness and some actions taken, and then things just kind of fade from visibility. They become obscured again, and it's like we're in a period of real darkness and gloominess. And then there's some awareness, there's some actions, but it just kind of goes in a cyclical way. It doesn't ever feel like it's a trajectory that's always going upwards, and that's profoundly discouraging. So what are the ways in which we can bring awareness and change that's sustained? And I want to pick up on something Emilie said, which is this is one of the problems with just turning to a criminal code reform. It often obscures, it has had this role for a long time. It obscures the real work that has to be done around changing social assistance and social housing and all of those various systems of support. It makes it seem like the solution to gender-based violence is far, far, far too easy. And it's not easy. It's really hard. And there's a huge amount to be done. And then the last thing, okay, a word of hope is Deepa and I have for a long time directed this feminist advocacy program. And we have a lot of students who give me hope that at least for the legal profession, that it is changing, and that changes for the good. It's way more diverse than it was even 10 years ago, and that some of it, the norms and values are changing, and so I think there is some hope there. So I'm not sure. I think it's Deepa who's next.
Thank you so much. I think definitely I'm with you on Janet with hope that and to be honest with you, something that I want to offer all of you from my own personal experiences, that if you work in the area of social justice, it's really important to take care of yourself and have hope, because otherwise working in this area starts becoming really not right. So being that trauma-informed services that we expect from our justice system and we expect from our our enforcement, that trauma-informed care needs to be offered to all of us, as well as the service providers and interveners in this area of work. So that's my one first quick offering for hope. In terms of the whole notion of why criminalization of an action doesn't really have worked for us, because we have never really fixed the problem in the system. And we have always run for the solution. And many of you must have heard me say this before. I saw this happen with the forced marriage issue, that it was criminalized. And look where we are in terms of data gathering, in terms of research, in terms of investment of dollars into understanding the scope of that behavior. And that's my fear, that we will have another code on the books, and there will be no investment into development of any evidence-based policies and interventions that really coercive control behavior requires. Going back to the Mass Casualty Commission, as well as Renfrew County Inquest, and interestingly, this was maybe Universe doing it at both of these inquiries, and were happening almost simultaneously, and their recommendations were coming simultaneously. There is one in particular which is really intriguing, and I would offer all of you to kind of think about it. There is a recommendation that there needs to be a collaborative consultation. I think Emilie just spoke about it, and that all provinces and territories should work with support sector, policymakers, legal community, so that there can be a public and education awareness campaign about coercive control. So that's Mass Casualty Commission's recommendation. And within that recommendation, they also endorse a recommendation from the Renfrew County Inquest, number 38, which says that to ensure that IPV-related public education campaigns address IPV perpetration, it should include men's voices, represent men's experience, and prompt men to seek help to address their own abusive behaviors. From the clinic's perspective, as part of our own strategic thinking, we have always said that we can't really think of a problem and a solution unless and until we really engage with all. And I think that is something that all of us should start thinking about. People, especially who are designing solutions, need to start thinking about that. And another thing, which is that the Master Agency Commission has coercive control mentioned at least 10 times in the entire report, and our policymakers choose to look at it only one thing. And that has not, again, it's a tragedy that I have not seen play out only once. I have seen it play out many times before, that, there will be a documentation with recommendation, and the lawmakers or the problem solvers who want quick solutions only go to one or two things and they forget. So I would invite all of you to look at that document, look at those recommendations. And I think part of this, being the part of the solution, is also on us. And one of the recommendations is that we should be investing in programs and projects which address coercive control. And I feel really proud that, this today's conversation and all of you engaging are doing that one step towards it, which is the part of the recommendation from the commission. So that gives me hope. And clearly, if I haven't been clear on saying that we do not support criminalization, because we feel it is putting the horse before the cart kind of a situation. We have far more deep-seated challenges in the system that need to be taken care of. But do we need to have conversation about public education on it? Do we need to have talk about the policy reforms, which makes experience of survivors without bias and discrimination? Absolutely so. And yes, I think I'll keep it short, but I just want to say that hope is there, but the system has failed survivors for far too long. So sometimes on a dark days, it's really hard to keep it up. But then as Arundhati Roy says, on the quiet day, I can hear her breathing. The change is around. So on a quiet day, I can hear her breathing.
Thank you.
Oh.
Emilie, I don't know if you want to speak to hope.
I do. I always want to speak about hope. That's like my
Sounds
favorite
great.
thing to talk about. Deepa, my quote that I chose many years ago when I started my Instagram account was that Arundhati Roy quote, "A new world is possible, and on a quiet day I can hear her breathing." And I love that quote, and I love hope. Mariam Kaba, who's a really well-known prison abolitionist in the United States, says that hope is a practice. And I think about that all the time, because we can often get discouraged in this work. And so we have to keep up our practice of hope by having conversations like this and by finding the places of hope where we can. And on the point that you were on men and masculinity, I'm reading a book called by Bell Hooks called The Will to Change. And it's on men, masculinity, and love. And I've been thinking about, Bell Hooks is brilliant. Some of the things I don't 100% agree with, but she is so brilliant. And what she says in this is that the first victim, I'm butchering it, but the first victim of toxic masculinity in a man's life is often himself, because we put men into such particular boxes under the patriarchy, just like we put women in boxes under the patriarchy. And so we do have to invest in smashing the patriarchy. And that gives me hope, because we're all going to be doing that. And thank you. Hope is a practice and a discipline. I was at a conference recently on Monday. Sorry. And there was a man there from an organization called Good Guys, which is something caught in my throat. Sorry, which is spelled Guise, Good Guys, that way. And they work with men who have perpetrated violence to actually think about their violence and how they are going to address it in their lives. And that is a program that gives me hope. There are lots of little ways that people are gathering together and addressing these issues. And it goes all the way from having a conversation with a friend about why we shouldn't criminalize coercive control to our organizations presenting at committee about why we shouldn't criminalize coercive control, and how we need to talk about intimate partner violence in different ways. So there's lots of hope there. We just have to keep finding it and practicing it, is how I would like to end.
Thank you. Thank you to all of you. We do have some questions in the chat, so we'll take a little bit of time to address them before we'll go for a break. We're just going to shorten the breakout groups just a little bit so we can accommodate. So one of the questions that I'm just trying to scroll up to because I scrolled down. Just 1 second. I've had lots of conversation in the chat, which is really great. Thank you all. So what about the criminalization of women by the CAS system that get listed as the maltreater in verification reports because of the issues arising from partner violence? How do you balance the protection of children through reporting violence without having to be criminalized as a result of being a victim? I'll let whoever wants to stand up, take the stand first. Go ahead.
Maybe I'll start with just a couple of thoughts, and Deepa and Emilie can chime in. I think there's a huge problem that I think most child welfare protection agencies are, in my view, massively under-resourced. So I want to acknowledge that I think often those who work in that environment are under like considerable strain. It's very, very difficult work. I think that often means that they have far fewer resources than they should have to provide to families. That is, access to housing or access to adequate income, etc. There's just far too resources. My sense as well is that that's one of the domains where deepening knowledge around coercive control is enormously important. It's important for decision making that happens within child welfare organizations, but it's also really important because judges almost always, there are some exceptions, will rely on findings made by frontline child welfare workers about whether or not the domestic violence has been verified. They don't always, but they just so often rely on those outcomes. So it has really important ramifications. That means that having both really sound knowledge of gender-based violence and coercive control and how it plays out it's so important, but also being able to have the time to do thorough investigations. I think, Emilie, maybe you raised this in the context of thinking about the criminal law system, but to actually understand what's happening in the life of a survivor requires a lot of trust, and trust requires time. And I think often frontline workers don't have that time to really to build that trust. And so the time is a really important resource that's needed.
Thank you, Jenna. One of the other questions we have here is, what are some ways that the police or other organizations would or should work to untangle such claims? I think these are claims that she's actually the one that's being abusive. Parental alienation, those kind of claims, and determine the underlying truth of the accusations.
And I can start, and then hopefully Emilie and Janet can chime in. In terms of how cops should be doing their job, it lies in again, somewhat similar to what Janet was talking about, the resource issue and how the structures are created, right? So the structures are created in this mandatory charging policy, which means that, let's not take the situation of violence at home lightly, because that is the historical construct and culture in which these policies were made. Unfortunately, the policy was created, but probably not supported with the right kind of resourcing of specialized officers with specialized skills and training. And I think that's where the missing link is. We don't have people who are invested in understanding the context of the violence in which the violence is happening. They are under pressure to make a decision of that I have to charge one of these two people or both, because I can't walk away from this situation without charging someone and not have the full context. Speaking of that, the full context also involves what rest is happening in this family, what else has been going on. It's just not that incident that is in front of my eyes. And that's where the coercive controlling behavior, the whole web of that lies. And unless and until you take time in making a decision and spend time in unraveling what all is happening, you will be making a rush decision. And we all know this in the line of work that we are in. If you don't slow down while getting a disclosure of abuse, you will get a wrong disclosure. That's like inevitably, doesn't matter what side of the table you're sitting on and from which angle your point of entry is in the situation, you will always make a wrong decision if you're rushing yourself. And I think that's the repetition that we are seeing in case after case in the cases of why police officers are making wrong decisions. And I feel at the core and the crux of it is a resource allocation of having a policy for the right reasons. Again, remember, I think Emilie said this, that intentions sometimes are really, really right. It's the right intention, but it plays out very incorrectly in the situation because they don't have the bandwidth, the time, the resource, and the training, and the skilled training that you need to cater to those situations. And some officers do it right? I also don't want to say that everyone is getting it wrong. There are some people out there who are getting it right, and they are doing it right. And they are also part of the same system. So it's not that we don't have model behavior to actually learn from and say, this is how you do it. Unfortunately, those are so far and few that we don't have as much role modeling in the system for people to actually curate themselves, unless and until there is a bigger policy shift that is made.
I worry a little bit about us continuing to depend on the existing system of policing to respond to intimate partner violence also. Like, I think in these conversations, we should be imagining alternatives or a separate solution. When we say alternatives, we are solidifying the existing system as the main system and everything else as an alternative. So let's say other systems, because one thing, this is not particularly related to intimate partner violence, but as an example, in the US, one of the states put in place 988 instead of 911 to deal with people who are calling about mental health crises. And they've had thousands and thousands of calls to the 988 number. And the people who respond there are trained in de-escalation and really understand mental health issues. And so they aren't police officers who arrive in police uniforms with weapons. They are people who, are probably well trusted in the community, have developed relationships with people because we often know the people who cycle through the systems. And so in that case, I mean, look, there's systems are ripe for bias to come forward, especially in cases where people are acting really quickly, right? Like we then fall back on our existing biases. We know that to be true. Doesn't matter how much training we've had. And we have bias steeped into our understanding of the world from very young ages. And so there's a particular way that we understand how women should be responding to situations of violence. And if women don't respond that way, then they must not be getting hurt, right? Like, especially in communities where, people can have those stereotypes or tropes about particular communities. And if that person, that woman, responds in an angry way or a loud way, or is frustrated, or has used a substance or something, then we don't believe her. That's not a perfect victim, which is why I think everyone should read this book, Imperfect Victims, because that is how we start to understand how bias continues to be played out. And so that's why I invite us to, while these systems exist, certainly think about how we can address them, but also to spend just as much time or more time and investment in other ways that we can respond. Because, and I think that if we have those, overarching experts who are in all of the provinces and federally who can connect on this and are very thoughtful, we may be able to come up with something that actually starts to make a difference. So that's how I would respond to that one.
Emilie, I'm hearing another project. But saying that, I just want to say that, many of you know this, and I talk about it all the time, that I became a lawyer in India before I came to Canada, and became a lawyer here again and started my practice second time round. So my first inning was in a jurisdiction which had a lot of indigenous ways of their own justice system, and then they also had their colonized justice system. My fear of any alternate is that unless and until the alternate doesn't have the misogyny that recreates itself, I'm fine with imagining new things. My fear is that unless and until that imagining and that designing doesn't happen in a space where misogyny can actually be kept on the side and never interferes with that space, the system, if alternate or other, whatever we call it, they start perpetuating the same biases and same kind of oppressions against the survivors. And because women's role at the core is always seen as, oh, you are the peacemaker, right? And unfortunately, how many peacemaker organizations are led by women all around the world, and we still are kept in that box, right? So that's the piece that I feel like is another project, and we should definitely connect about that.
Maybe we'll take one more from the chat. Are there any recommendations on sources of studies done on post-separation abuse or litigation abuse used in family court? How can you be proven that this is what is occurring?
I was going to say that there is quite a bit of published literature. Maybe if we could put together a list to share with attendees afterwards. There was a report done some years ago by Pamela Cross for Luke's Place on litigation abuse. And there's a fair bit of American research, not so much Canadian research. I think I mentioned this project I'm currently involved in, looking at recent family law decisions. And one of the things we're looking for as we go through those decisions are various ways in which litigation abuse is manifesting. But that paper will be a little ways down the road, but I'd be happy to put together a list of the pieces that I know. And then I think it's probably some judicial education, and not that it's always an easy answer or a complete answer, but understanding the ways in which processes are used in a manipulative and abusive manner. And judges have inherent jurisdiction to control their processes, and they are to ensure that those processes aren't abused. And so helping them to understand the ways in which those cleverly manipulative perpetrators are actually abusing the processes, I think is a piece of the work that has to happen too.
We have a few more, but I'm a little bit worried that we won't be able to get a break. So I think I'm going to introduce the breakout questions now, and then we'll go into a break. So I encourage you all to to stay on the call with us and participate in the breakout groups. I think it's going to be a really great chance to do some
Thinking
have some
together.
conversation. Thank you. Have some conversation around this issue and what different regions are doing and what can be done in different regions and what the experiences in different regions. And yeah, so with that said, I'll go into the questions. You'll be provided this during the breakout sessions, but I just wanted to give you a little tidbit before you go on break. So hopefully it catches your interest and you stay with us. So what are the main or most common gaps in policies, laws, and services for survivors facing criminalization? What kind of services are available to criminalized survivors in your region that you're aware of? And what more is needed to address the criminalization of survivors? What work are you engaged with? So with that, I'll give everybody a 10-minute break and then we'll come back and we'll assign you group rooms. So thank you, everyone.